5 seconds to go. Start. That in the absence of proof of receipt of gratification, mere demand does not constitute an offence under section 13(1)(d)(1) and 2. Stop. But if demand is construed as an attempt, then such an attempt to obtain is an offence under section 7 of the Act. Stop. Para. Further, under section 13(1)(d)(1) and 2, obtainment could be proved by oral evidence, documentary evidence, statutory presumption, and circumstantial evidence. Stop. That the person to whom the demand was made could let in oral evidence, and the same is direct evidence under sections 59 and 60 of the Evidence Act. Stop. Further, if anybody else was present at the time of making of the demand, his oral evidence would also be direct evidence, and the same may be sufficient to prove the demand. Stop. In case the person to whom the demand was made is either dead or unavailable for letting in evidence or turns hostile, and there is no direct eyewitness account of the fact of demand, then, in the absence of any other evidence, the accused is entitled to acquittal. Stop. However, if the demand is evidenced by any document, such as demand being made through email, letter or any other communication, the said fact could be proved by documentary evidence in the absence of any direct or oral evidence, although the complainant or the person to whom the demand has been made is not available to let in evidence. Stop. Para. It was further submitted by Shri Nagamuttu, Learned Senior Counsel, that section 20 of the Act mandates a presumption to be made by the court, which is in the nature of a legal presumption. Stop. The presumption in relation to any illegal gratification accepted or obtained or agreed to be accepted or deemed to be obtained as motive or reward, as per section 7 of the Act, is a restricted and conditional presumption. Stop. The said presumption can be raised only on a proof of acceptance or obtainment or agreement to accept or attempt to obtain the illegal gratification, and is not a presumption of guilt of an offence. Stop. Para. That the legal presumption that could be raised under section 20 of the Act is in contradiction to a presumption that could be raised under section 114 of the Evidence Act. Stop. By citing an example, it was so to be contended that, if tainted currency notes are found in the possession of a public servant in a trap case, there can be a presumption under section 114 of the Act that he might have received it. Stop. But this is a rebuttable presumption, that the accused can rebut this presumption by offering his explanation for the possession of the tainted notes. Stop. The said presumption is a presumption of fact. Stop. However, there can be no presumption of demand as such. Stop. In other words, the demand as a matter of fact cannot be presumed under section 114 of the Evidence Act, unless for such a presumption to be made, the foundational facts are proved, and such foundational facts unerringly point to the irresistible and only conclusion of proof of demand. Stop. This would imply that mere recovery of the tainted notes from the possession of the accused would not give rise to a presumption of demand. Stop. In this regard, reference was made to B. Jayaraj. Stop.